Dear participants, we are so excited and happy to welcome you to the launch event of KHAS University Climate Change and Law Laboratory, which is also the very first session of our Climate Change and Law seminars. It's our privilege to have Professor Christina Voigt with us today for her lecture on current issues of international climate law. Before the lecture, we kindly want to ask for welcome remarks from our rector and our dean, who are also with us today. Without further ado, I want to leave the floor to our rector, Professor Sondan Durkanoğlu Feyiz first. Please, Professor.
Thank you, Ece. And dear attendees, as you know, climate change is one of the greatest environmental challenges humankind faces. It is for sure not just a survival issue for us. Any policies dealing with this challenge will for sure have individual, institutional, and societal rights and responsibility issues. And this is exactly when the academicians should enter the game and start the fruitful discussions on the issues. The law schools around the globe should take the responsibility and, as I said, start the discussion on these issues. At this very point, I am very pleased to see that the law school at KHAS University is taking the leadership in Turkey by building a virtual lab. Please do not imagine that this is a physical lab, a virtual lab on climate change and law. For that, I am very thankful to Başak Hocam, the Dean of Law School at KHAS University, and of course, for sure, Aslan Hocam for establishing this virtual lab. And I am very sure that the lab will do its best to serve the society in these very important issues. And I would like to also thank today's speaker, Christina Voigt, and all participants for becoming part of today's kickoff event. And I leave the floor to the lawyers, and I'm going to be listening. Thank you, Ece and Christina.
Thank you. Many thanks, Professor Feyiz. Now I want to leave the floor to our Dean, Professor Başak Baysal. Please, Professor.
Thank you, Ece. Thank you, Professor. Thank you, Professor Feyiz, our President, for the welcoming remarks. And as a Dean of the faculty, for me also it's a great pleasure to welcome all our participants and Professor Voigt today to the launching event of KHAS University Climate Change and Law Laboratory. As you know all, we are getting over a difficult summer where we have experienced many severe results of climate change in Turkey and also worldwide. In addition, day by day, our worries increase with the release of related scientific research. As always said, we are the first generation to feel the impacts of climate change this closely, and probably the last generation that can do something about it. By believing that every contribution is invaluable in the struggle against climate change, we decided to take action. This led us to establish KHAS University Climate Change and Law Laboratory. I'm proud to announce the establishment of CCLLAB. It is a crucial step representing the stance of our faculty against climate change, but I'm also happy to inform you that our faculty's work on the legal side of the issue will continue. I want to take this opportunity to thank members of our faculty and members of the laboratory, Dr. Aslan Erbaş Açıkel as the coordinator, and Ece Uyanık as the vice coordinator for their efforts to establish the CCLLAB. We appreciate all your hard work and dedication. You have inspired us all. Many thanks to our president, to our rector, Professor Dr. Feyiz, for her support from the very beginning of our project. Finally, we are glad to host Professor Christina Voigt at our launch event. Thank you, Professor Voigt, for accepting our invitation. It's an honor for us. I wish you all a fruitful conference, and I'm giving the floor again to Ece. Thank you.
Thank you, Professor Baysal, for your kind words. Now, just before the lecture, I want to invite coordinator of CCLLAB, Assistant Professor Aslan Erbaş Açıkel, for her introductory remarks on our CCLLAB. The floor is yours, Professor Açıkel.
Thank you so much, Professor Feyiz and Professor Baysal, for your opening remarks and your very kind and encouraging words. Dear professors, dear Professor Voigt and all participants, it's a great pleasure to welcome you to the launching event of KHAS Climate Change and Law Laboratory. We are particularly delighted to have Professor Christina Voigt from University of Oslo. She is one of the great experts on climate change, and before I hand over to her, I would like to shortly introduce our laboratory. KHAS University Climate Change and Law Laboratory, shortly CCLLAB, was established by KHAS University Law School with a view to contribute to the global efforts taken by the academics, professionals, scientists, citizens, social societies, and students to fight the climate crisis, to take immediate climate action, and to help transition towards a sustainable future. By asking ourselves at the university, what can and should we do to the best of our abilities, we come to the conclusion that the first and foremost, as law educators, we could influence the law students, and by doing so, the future lawyers and lawmakers, by updating our school curricula, which would foster awareness and sensibility on the climate catastrophe, and also train and enable them to effectively use the tools of law against the climate crisis. We could further commit our legal research to highlight different problems posed by the climate change and look into other law systems to see what solutions have been found out already and how the law and court decisions have reacted to prevent, mitigate, and manage the climate crisis. With these initial motivations in mind, we have established CCLLAB to create a long-term platform for legal education and research on the legal side of struggling climate change. In this sense, CCLLAB will create an opportunity to get together with world-known experts, legal scholars, and practitioners on legal aspects of climate change by organizing monthly seminars, namely climate change and law seminars. The series will plan to cover different aspects of climate change and law, such as climate justice, human rights and climate change, status of climate asylum seekers, sea level rise and related legal problems, such as the survival of states without land territory, its effects on the existing maritime zones, ecocide as a new type of crime, corporate responsibility, and many other aspects of the topic. Last but not least, CCLLAB feels responsible to introduce this critical field to Turkish legal scholars, practitioners, and local authorities in order to contribute to the discussions on the development of Turkish law policies and legislation addressing climate change. I would specially thank to Ms. Ece Uyanık as Vice Coordinator of the CCLLAB for all her support in the establishment of the CCLLAB and organizing this event, and also to our Dean for encouraging us, and also for Professor Feyiz, our President, for all her supports in the establishment of the laboratory. Yes, today CCL hosts a world-known expert, Professor Christina Voigt, and is honored and feels privileged to start his seminars with her lecture. Dr. Christina Voigt is a professor of law at the University of Oslo. She is an internationally renowned expert in international environmental law and teaches and publishes widely on legal issues of climate change, environmental multilateralism, and sustainability. From 2009 to 2018, she worked as principal legal advisor for the government of Norway in the UN climate negotiations and negotiated the Paris Agreement and its rulebook. Professor Voigt is chair of the IUCN World Commission on Environmental Law and co-chair of Paris Agreement Implementation and Compliance Committee. Professor Voigt, The floor is yours now.
Thank you so much, Professor Abbas Ashikel, for your very kind words of introduction. Before I say some more words of thanks, I would like to start to congratulate the KHAS University, especially your president, Professor Faiz, for her leadership and foresight and wisdom to cooperate together with you, to cooperate with the Dean of the Law School, Professor Baisal, on establishing the Climate Change Law Lab. I think this is a very, very important initiative. It shows that your university is able to understand the signs of our time, to understand the urgency and complexity of the challenge of climate change, and to what extent rights and duties, as the President Faiz mentioned it, are core of these questions. And these are questions of rights and responsibilities that are of international nature, but they also all the way trickle down to very specific individual and national legal questions. So let me congratulate you to the establishment of the CCLLAB. It's a great achievement, and I'm very, very proud and privileged to be invited to speak at the opening seminar. So thank you so much to Professor Faiz, to Professor Baisal for inviting me, and thank you again, Professor Ashikel, and also to AJ for inviting me and working out the logistics with me. It's a great pleasure being here. Now, what I would like to do today with you, with the audience, is to give an overview. And it's not a comprehensive overview. There are many aspects that I probably won't be able to cover about this field of international climate law and a number of current issues, legal issues that are really cutting edge legal questions that demand resolution, that demand research. That's why academia is so central in thinking through these questions, and where a lot of legal work still needs to be done. I'll try to share my presentation. I hope it works. Okay, so that should go fine. So I titled the presentation International Climate Change Law, and I'll attempt to give an overview over current issues, but I said from the beginning, it's not exhaustive. There are many more that I probably will not be able to dive into, but I'll try to give you a little bit of a tour de force of what is out there currently in legal debates. So the way I structured this, I would like to start with providing a definition of what international climate law is. And then I'll very briefly just say a couple of words about where do we currently stand in terms of climate science. Now, I'm a lawyer, I'm not a natural scientist, so I keep this short, but I think it's important to understand the discourse and the debate to know what the current best science is. And then I'll delve into 6 different areas of international law, and just to give you an overview of what we have. I'll spend quite some time, of course, on the United Nations climate treaties, and there in particular on the Paris Agreement, not because I work quite a lot on it, but because I think it is really currently the most central and the most important international treaty that we have in the field of climate change. I also say a couple of words about what we can expect from the UN Climate Summit in Glasgow, which is just about to start at the end of this month. Then I'll dive briefly into the area of human rights. I can only touch the very tip of the iceberg, really, but I'll give you some ideas about what kind of discourses and discussions are happening in human rights law currently with regards to climate change. Then I'll address some issues of investment law, trade law, bilateral free trade agreements. I'll also go into briefly into international law of the sea. And we just heard already some indications of climate impacts in terms of maritime zones, access to new maritime routes, and I'll say some words about the role of international law of the sea in this context, before I then briefly say some words about customary law, where we don't have a treaty, but we have international custom. And then finally, I'll wrap up with some reflections about very general international law on peace and security and the role of the Security Council. So let me just start this brief presentation. I'll keep it to an hour. And if I get close to the hour, maybe somebody can say that I have like 5 minutes left. Okay, let me start with an attempt of a definition of what it is actually when we talk about international climate change law. That is the definition I usually work with, but there may be several others. But for the context of this presentation, it might be helpful to set out what we're talking about. So when I talk about international climate change law, what I mean is international law, which is law between states or states and international organizations that either directly or indirectly deals with addressing the causes of climate change or its adverse effects. When I talk about directly, then it's the international climate treaties, the United Nations Framework Convention on Climate Change, or the Paris Agreement, which as their overarching direct goal aim at addressing the challenge of climate change. But we also have, of course, other international areas, law areas that also in one way or the other address climate change, but from their respective fields and do not directly aim at addressing climate change, but more indirectly have a connection with it. And you say, I also mentioned addressing the causes of climate change as well as its adverse effects. So talking about the causes of climate change would be legal norms that address the reduction of greenhouse gas emissions, that deal with how do we actually reduce greenhouse gas emissions and increase removals, for example, protecting forests and soils or oceans, but also with the adverse effects of climate change. How do we deal with the consequences of climate change? And that links to the whole field of adaptation, but also loss and damage, migration, conflict, and everything that deals with how does climate change impact human societies. Now, under this definition, you can actually see this whole, what can we call it, like a flower or something with different petals. This whole range of different international law that links into the issue of climate change. And this is, as I said again, this is not exhaustive. There are other areas, for example, international criminal law, which I didn't put here in, but it is this intersection of different areas in international law when we talk about climate change, which makes it very interesting, of course, but it makes it also challenging because you actually have to understand many different areas of law in order to understand how international law can and does address or even come in conflict with measures taken to address climate change. But these are the aspects that I'll discuss very briefly in my lecture today. And as I said, it's really only on an overview level, just to give some ideas that can maybe be addressed in later seminars that then can zoom in on these particular topics. Let me start with the scientific basis. And I usually start with the Paris Agreement, but this is of course not the scientific basis, which I will come back to in a second. But the Paris Agreement in its Article 2 contains this global contract, this global understanding of climate change is something that's happening, and it's happening while we speak. And we have to stop it somewhere, and where to stop it, that's a political understanding. It's a political consensus and finally legal consensus, which was included in Article 2, which I'm sure many of you know, where it says that the Paris Agreement in enhancing the response to climate change it aims to hold the increase in global average temperature to well below 2 degrees centigrade, above pre-industrial levels, and pursuing efforts to limit temperature increases to 1.5 degrees. And it's important to have this general guardrail of where to stop climate change in the back of our heads when we talk about the scientific basis, because we can have very many different scenarios, but it's important to find a scenario for greenhouse gas emissions that is consistent with that overall political and social agreement that states have adopted in Paris. In terms of science, of course, the most important basis for science are the assessment reports by the Intergovernmental Panel on Climate Change. These assessment reports do exactly what they say. They assess the current status of science worldwide. The IPCC itself does not carry out any research, but it keeps an eye and surveys international science, over 3,000 scientists worldwide, and assesses what the current status and the cutting edge of climate science is. And every 5-6 years or so, it publishes an assessment report, and the latest one is currently in preparation. It will have 3 parts. And the first part of the 3 parts of the 6th assessment report was published about 2 months ago. But there are another 2 parts coming next year in March and April. The first part of the 6th assessment report deals with the physical basis of climate change. And the second and the third part to be published next year will deal with the impacts of climate change, and then also with the required measures to address climate change. But the first part, which was published this year, already gained very significant attention worldwide, because it sets out, it says many things. It says, for example, that we're already looking at global warming at about 1.2 degrees. So we're getting closer to that guardrail that the Paris Agreement has set. But the report also establishes 5 scenarios of how emission trajectories will continue over the course of the century. And all 5 scenarios are realistic, all 5 of them possible. It really only depends on the choices that we are taking today at which scenario we're ending up by 2100. But out of those 5 scenarios, there's only one that actually would keep temperature increases to well below 2 degrees. And that's the one on the very top of this table, which is cut and paste from the IPCC 6th assessment report. And if we look at what that scenario implies, we also have this graph also from the IPCC, and that scenario is the light blue line, which is at the very bottom of those 5 scenarios. So we are seeing that we can look, if you just go back here, sorry, just one, one step here. This scenario might keep warming to somewhere close to 1.8 degrees, which is well below 2 degrees, while all the other scenarios will overshoot 2 degrees, all the way to possibly even 5.7 degrees if the world is taking this road under the 5th scenario. So if we're seriously, then this is really only this top one, or maybe the bottom 2, that might with high likelihood guarantee that the world can keep warming well below 2 degrees. But if we look at what this implies, we're seeing an immediate and drastic reduction of greenhouse gas emissions. That is only CO2, carbon dioxide in this graph, immediate reduction all the way to what is called carbon neutrality, net zero emissions of CO2 around 2025, and then continuing to be negative until the end of the century. So this is what needs to be done. This is what science says. This is the scenario, how emission reductions have to happen in order to keep within what you agreed to in the Paris Agreement. This is the same what I just said, just in words. And of course, every other scenario will lead to a different world. Every ton of CO2 emissions, every percentage of increase of temperatures will lead to a world that looks significantly different from the one that we are knowing, the one that we evolved in, and the one in which orderly systems, including the legal system, evolved in. And it's very clear that keeping emission reductions, reducing them immediately to net zero and negative emissions thereafter, is not an easy task. The IPCC is very clear that this is something that has to cut across all sectors, pretty much everything we do, and that these systems transitions are unprecedented in terms of scale. And they raise many questions of legal responsibility, legal regulations, of rights, of duties, of which kinds of laws can be applied in order to get to make these system transitions happening. We're also looking at the possibility, and I won't address this in any detail in my talk, at new technologies that many think might help us to address this challenge, where certain installations may help to suck out CO2 out of the atmosphere. At some point, that may be the only way to reduce greenhouse gas emissions and keep warming well below 2 degrees, but we're not there yet. But in all these new technologies that can deal with ocean fertilization or carbon capture and storage, or even direct air capture, international law and national law will have to play a significant role. And I only included this slide here to indicate that there's a lot of thinking out there about negative emissions, but there is not very much legal regulation, especially under international law yet, about how to address these different technologies. So just to wrap the scientific part up, what is needed in order to keep temperature increases to well below 2 degrees or even 1.5 degrees is what is referred to as transformative change across all sectors of society. And it applies both to reducing greenhouse gas emissions, maybe even through the use of new technologies, which raises legal questions, but also by addressing the adverse effects of climate change that's already happening, and it will continue to happen. The extent of adaptation depends on how much we can reduce emissions right now, but both mitigation and adaptation have to be addressed through legal means. And finally, adaptation can only get us so far. It is well understood there will be climate effects and consequences which are beyond adaptation, which lead to loss and damage, which also, of course, is an area of international law that needs further development. Now, let me focus on the United Nations climate treaties. Very briefly, you all know we have 3 international treaties in force, and they're legally binding upon their parties. Important is the United Nations Framework Convention on Climate Change, which is kind of the constitutional background treaty, which is in force and is currently, of course, something that informs the Paris Agreement, but has been enhanced in its implementation to the Paris Agreement. Then there is the Kyoto Protocol, which is also still in force, although it does not have any new commitments that parties took upon themselves after 2020. But the protocol itself is still there. And then, of course, we have the Paris Agreement, which was adopted in 2015 and entered into force and record speed in less than 1 year. And I would like to comment Turkey on its recent ratification of the Paris Agreement, and looking very much forward to having you joining the meeting, of course, in Glasgow, which will be a very, very important one. I'll come back to that in a second. As I already said, the Paris Agreement is a legally binding treaty. There is no question about it upon its parties. It currently has 191 parties, which is almost universal if you consider that there are a little less than 200 states in this world. So 190 states are members to the Paris Agreement, plus the European Union as a regional economic organization. So that makes it 191. The agreement itself contains both legally binding obligations, that's everywhere where we see the word shall, but it also contains provisions that are, of course, not legally binding, where it says parties are invited or encouraged or welcome to do this or that. But this is something that we have in every international treaty. It is possible to withdraw from the Paris Agreement. We've already seen one withdrawal by the United States, but the United States rejoined the agreement in February this year. It was only out for about 3 months and is now a party to the Paris Agreement again. The object and purpose of the agreement is to enhance the implementation of the United Nations Framework Convention on Climate Change. The Framework Convention, as I said, is a fairly general agreement. It was adopted in 1992 and doesn't really contain very specific obligations. And it also put the world into different annexes, where we have an Annex 1 for developed countries, and developing countries are not listed in any annex. And according to whether you are in an annex or not an annex, different obligations applied. Now, moving away from how the world looked like in the early 90s to being something that is commensurate to the current geopolitical reality is why we have the Paris Agreement, which drew in or is applicable to all parties, no matter whether they're developed or developing countries. I'll come back to that in a second. And the aim of the agreement is, of course, to enhance the implementation of the convention and to strengthen what we have on climate change, strengthen the global response to the threat of climate change. I'll just very briefly run through 5 main facts of the Paris Agreement, which I think probably are very well known, but it may not hurt to briefly repeat them. First of all, the goals of the Paris Agreement. I already mentioned the temperature goal to keep temperature increases to well below 2 degrees or 1.5 degrees. It's listed in Article 1, paragraph 1, but there are 2 more goals. They're in the same article, also in Article 1, but they're not so often mentioned and referred to. But I think they're important, and they have a similar legal importance and significance as the temperature goal. And this may be one of the current issues where we maybe see more focus as well on the adaptation goal as well as on the finance goal. This is, if you have never had a look into the Paris Agreement, this is how Article 2 is formulated. I already mentioned it on the global temperature goal. It is also important to know that the goal of keeping warming to 2 degrees or well below 2 degrees and 1.5 degrees is made more specific in Article 4, paragraph 1 as well, where it says that in order to achieve that long-term temperature goal as set out in Article 2, parties aim to reach global peaking as soon as possible, meaning that we don't increase emissions anymore, but they peak. And undertake rapid reductions thereafter with the aim of achieving a balance between anthropogenic emissions and removals by the end of in the second half of the century. And this sentence in Article 4 corresponds very well to the graph by the IPCC report that I showed you just now, where it says we have to peak and there have to be rapid reductions thereafter with the aim of balancing emissions and removals, which is just another word for climate neutrality. But it doesn't mention that then you have to stay negative until the end of the century. So the 2 other goals, which are also very important, is the adaptation goal, Article 2, which talks about increasing the ability to adapt to the adverse impacts of climate change and to foster climate resilience and low greenhouse gas emission development. And the finance goal, also Article 2, paragraph 1, and here litera C, which talks about making finance flows consistent with a pathway towards low greenhouse gas emissions and climate resilient development. And as I said, we hear a lot about the temperature goal. We don't hear that much about the other 2 goals, but from a legal perspective, they are written into the same article and have the same legal standing and normative force. And in particular, the 3rd one is maybe something that legal scholars could or should or are already working on quite a bit more. What are the legal implications of this overall goal to make finance flows consistent with the pathways toward low greenhouse gas and climate resilient development? What does it mean? What impact does it have, for example, on international trade agreement, on investment law, on any fiduciary standard that you have domestically and so forth? There's a lot of normative force in this goal as well, which still needs to be explored in much more detail. And as you see here, I just pointed out to current issue. I have this throughout my presentation that I point to some current issues that are very interesting and where lawyers can contribute to the overall international discourse. The second point of the Paris Agreement are nationally determined contributions. Each party, whether developed or developing country, each party is under the legal obligation to prepare, communicate, and maintain what is called an NDC, a nationally determined contribution. And here the legal obligation is to communicate or to prepare, communicate, and maintain such an NDC but what a party writes into it, which kind of target it sets for itself or goal, what kind of measures it will adopt nationally, this is not part of the legal obligation. The legal obligation is a formal one to communicate basically to the world an NDC. But whether it is achieved or not is something that, at least under the Paris Agreement, is not legally binding. The agreement has been criticized for that, but it is part of this overall give and take, this overall consensus that needed to be found in Paris in order for the world basically to be able to agree on it. Each NDC, and parties are supposed to put forward an NDC every 5 years. So it was 2020 was the start of the first NDCs, 2025 is the next round, 2030 and so forth. So each 5 years, parties have to put forward a new NDC, and that will represent a progression in relation to the previous NDC and reflect each party's highest possible ambition. And that's the whole idea of the Paris Agreement, to increase ambition over time to make, in order to collectively address the climate challenge. I had a point here on a current issue, which is currently under debate and will be negotiated in Glasgow. It's a bit of a technical one, but I thought I mentioned it as well, because the Paris Agreement only says that parties have to put forward an NDC every 5 years, but the Paris Agreement doesn't say for how long an NDC is supposed to last. Is it for 5 years or for 10 years, for 15 years? That's something that is not decided, and it causes currently a bit of a challenge, because it is important actually for the overall functioning of the agreement that parties put forward NDCs with common timeframes. And this is one of the negotiation points that need to be agreed on in Glasgow. So this is this slide here, where I try to put some graphics into how the Paris Agreement works. This is supposed to show what the architecture of the agreement is attempting to achieve. Is that NDCs are due every 5 years, in 2020, 2025, 2030, and in between every 5 years, there's something called a global stocktake, which is supposed to take stock of the collective process of all parties and say, okay, collectively we're here. Compared to the overall goal, we should be there. There will always be a gap, but that gap is then supposed to inform the next round of NDCs. So the stocktake will be every 5 years, but in between the points in time where NDCs are due. So in order to be able to inform the next round of NDCs. So the first global stocktake, we haven't had one yet, is going to be in 2023, and the next one in 2028, and then so forth. And that in conjunction with the requirement that NDCs need to progress and be at the highest level of ambition, that's the whole idea within the Paris Agreement, to pull up ambition over time. I'll just briefly skip over this. One aspect which is also very central to the agreement is that parties are very transparent and open about how they are implementing and achieving their NDC. So in the absence of the content of the NDC being legally binding, what is more important is being transparent and open about how well you're doing, even though nobody can claim that somebody has not achieved its NDC and can be criticized for that. But the transparency is very important. And here a whole new transparency framework, or an enhanced transparency framework, was established that partly builds on the reporting requirements under the Paris Agreement, under the Kyoto Protocol and the Framework Convention, but it also lifts reporting up to a whole new level, where parties every other year, every 2 years, have to submit what is called a biannual transparency report, where they have to provide a lot of information about their national greenhouse gas inventory, but also on their NDC and how well they're implementing and achieving it. And every report, every 2 years, will go through a technical expert review. So it's a whole new mechanism that was set up in order to enhance parties' accountability and transparency under the agreement, but also, of course, to create trust and confidence that parties actually do what they said they would do, and to push up ambition. So this is starting with the biennial transparency report, going through a technical expert review. The technical experts come with a report, and then it goes to what's called the facilitative multilateral consideration of progress. And then it starts from the beginning again. Now, in the Paris Agreement itself, there are a lot of different elements, a lot of detail, but of course, not everything could be decided in Paris in 2050, all the detailed rules that would be necessary to effectively implement and operationalize the agreement. And for that reason, parties to the agreement for 3 years since 2015 until 2018 negotiated something called the rulebook for the Paris Agreement, where much more specific guidance was adopted in 2018 in Katowice at the Climate Summit on various aspects of the agreement. For example, what kind of information do parties have to put forward in the NDC? How does the reporting work? How does the review, the technical review work, and so forth? But one aspect or two aspects are still missing, and one is the rules for carbon trading under Article 6. Parties weren't able to agree on them in Katowice, and they were not able to agree on them the year later in Madrid at the Climate Summit. And then last year, we did not have a global climate summit. And that's why one of the expectations for Glasgow is to deliver on that. But there are also other issues, for example, the common timeframes for NDCs, which are still not decided, and some more technical elements under the transparency framework. This is just an example for those of you who may be interested on this issue with common timeframes. This is the current negotiation draft as it stands, and which will go into the negotiations in Glasgow, where you see different possibilities for how long an NDC should be for parties, at either 5-year time frame or 10-year time frame, or 5 + 5 years, or a 5 or 10 years. So there is actually currently no agreement, and I think it's going to be very important to resolve this issue in Glasgow. So where are we now? We had, I already mentioned the withdrawal by the United States, re-entry. We currently see a whole host of parties coming forward with new and updated NDCs, but also putting forward carbon neutrality targets for later on for 2050, including the European Union, but also recently countries like China and Brazil, China for 2060, Brazil as well. But these new, how can I say, pledges that states come forward with, I think can be directly linked to the existence of the Paris Agreement, although they're not necessarily mandated in the agreement. But I don't think we would see these pledges for carbon neutrality targets for 2050 without the Paris Agreement. And of course, the negotiations continue. They've always taken place once a year, except for last year, and there is no end in sight. And they're probably also very important to push ambition, to develop the legal framework further, but also to provide this meeting and convenient space for states, but also states and stakeholders, civil society, to meet and engage with each other. The Conference of the Parties, both to the Paris Agreement and to the Kyoto Protocol and the Framework Convention, will take place from the 30th of October to the 13th of November this year in Glasgow. And one expectation is, of course, to finalize the Paris Agreement rulebook at the blank spots that are still there on carbon trading, on common timeframes, and some other aspects. But there's also a whole host of expectations that are more of a political nature, for example, to close the ambition gap between where parties' NDCs currently are and where they need to be. There was a current NDC survey, the NDC synthesis report that was carried out by the United Nations Framework Convention on Climate Change Secretariat. And it stated very clearly that the ambition in current NDCs is not sufficient. It puts the world on a trajectory of about 2.7 degrees and not well below 2 degrees. So the political discourse in in Glasgow will be very important to find a manageable way forward to push up ambitions. There is also the expectation that the rules for the Paris Agreement Compliance Committee will be adopted in in Glasgow and a number of other things. My point here is that the expectation towards the COP in Glasgow, they're very, very high expectations. They're both of technical, legal nature, but also of political nature. And I think the success of the COP in Glasgow will be measured on both. So the parties will have to deliver both on the formal legal negotiations, but also on showing willingness to enhance, update the NDC, close the ambition gap, and also wrap up or increase the financial support to be provided to developing countries. Now, leaving the Paris Agreement and the UN climate treaties behind and moving around in this through the petals of the flower that I showed you initially, the agreement itself also has other and further implications in other areas of international and national law. Domestically, an effect of the Paris Agreement, although it's an international agreement, but many states, of course, have to implement it. Parties have to implement it into their national legal systems, national legal frameworks. Many countries have now adopted particular climate acts, climate change acts or regulations. So in the context of implementation, we've seen many changes to national laws and regulation as a direct effect of the implementation of the Paris Agreement into the domestic legal system. And we also, of course, have seen a rise in climate litigation worldwide. Not all of that is about the Paris Agreement, actually none of that is directly based on the Paris Agreement. But in many of these climate cases, reference has been made to the provisions of the Paris Agreement, especially Article 2 on the global temperature target, in interpreting national laws, for example, constitutional provisions or human rights provisions and so forth. So the Paris Agreement had a normative influence, although not directly applicable by national courts, but it had a very important influence in the context of interpretation and statutory application of national laws. I'll come back to human rights obligations and trade agreements in a second, so I go a bit more specific into that. But let's just very briefly zoom on into the issue of human rights law. You may know that in the context of the negotiations of the Paris Agreement, it was very important to give a recognition that climate change has a linkage with human rights, not both a factual linkage, but also a very important legal linkage, that protecting human rights will also depend on how well we are able to address that crisis of climate change. In the preamble to the Paris Agreement, there is a recognition that when parties take action to address climate change, they need to be recognizant of their existing human rights obligations. So what the Paris Agreement basically said was, it recognized that link between human rights and climate issues, but it said basically to parties, you have to take your human rights obligations seriously, and you have to consider what your obligations are under human rights treaties or customary law when you implement the Paris Agreement. And in a way, the Paris Agreement threw the ball back into the human rights field. And something very interesting has happened since then, where in many both scholarly articles, but also current cases, the link between existing human rights, for example, right to life, right to health, right to private life, has been interpreted in the context of climate change. And the question has been addressed, or is being addressed, of what actually are states' positive obligations to address climate change in order to protect and promote and respect existing human rights, for example, in the UN Covenant on Civil and Political Rights and other human rights treaties. We don't really have a final say on that, at least not on the international or regional level. We had some national cases, for example, in the Netherlands, in the Agenda case, but internationally, we don't really have any statement yet by any international regional court on the interlinkage between climate change and human rights. And in this situation, it is very interesting and very important to follow from a legal perspective that there are 4 cases currently pending before the European Court on Human Rights. 4 cases that all in different ways deal with interpreting or asking the European Court on Human Rights on finding what states' obligations are to protect rights to life and private life in particular from the impacts of climate change. How does that translate into emission reduction obligations of states? What is the duty of care? What is the obligation that states, the positive obligations that states have because there are parties to these, in this case, to the European Convention on Human Rights. This is, as I said, this is a very fascinating area to follow, and we're all awaiting the judgments by the European Court on Human Rights when they come. We also see currently attempts to use the UN human rights system, especially the committees under the respective UN human rights treaties, the Convention on the Rights of the Child, the UN Covenant on Civil and Political Rights. Each of these conventions have particular committees to which complaints or petitions can be brought. And there are currently several complaints pending before several of these committees. There was a complaint by 16 children against 5 states. That complaint was brought to the Committee on the Rights of the Child, the CRC, and that complaint was recently addressed earlier last week, where the Committee on the Rights of the Child, and I have this here, I'm sorry, ruled that these children didn't have what I can say legal standing or standing before the committee because they did not exhaust national remedies. They just went straight to that committee without using their court system in their respective countries first. But the committee went on to go into the detail on these complaints by those children and said that actually states do have an obligation to protect children and their interests and their rights from the disasters of climate change. And that does not only apply to children living in the particular territory of each state, but it also applies to children that live somewhere else in the world. And that finding of extraterritorial obligation under human rights law to individuals, in this case, children that live somewhere else in the world, is a very, very important one. And it will be very interesting to follow what the legal repercussions of this finding by the United Nations Committee on the Rights of the Child will be, maybe in national court cases or in other cases, which definitely will pick up that finding by the Committee on the Rights of the Child. I had a picture here of one of the cases that is pending before the European Court on human rights. This is brought by several Portuguese children against all member states of the European Convention on Human Rights. And as I said, it's still pending. So what we are seeing a lot of is a fairly young claimants or petitioners bringing cases on human rights, on a human rights basis against states to international courts or these UN committees, claiming their direct interference with their right to life and other rights, but also in an intertemporal manner where these children or young adults say, we're already worried about what's happening currently, but we are growing into a future where these effects will just enhance and even more affect our rights and interests in the future. And that intertemporal aspect is another very interesting legal or contemporary issue that I think lawyers will find very fascinating to follow. The third aspect that I wanted to mention, I think we already heard about it, is a lot of focus is now was directed against states, but it's now focusing on corporate responsibility, where we see an interesting legal development where also corporations, private actors are taking into account, and their responsibility is being established for inaction or not sufficiently ambitious action on climate change. One of the most interesting cases recently, earlier this year, is again from the Netherlands, where the district court in The Hague found that the Royal Dutch Shell company has an obligation to reduce its greenhouse gas emissions by 45% in 2030, but it doesn't only apply to the Royal Dutch Shell company in the Netherlands, but to all the subsidiaries it has in about 160 states, which I think is a very interesting legal finding. And it based this judgment on a tort law provision in the Netherlands, which establishes a duty of care. It's actually an unwritten duty of care, but in that particular case, the Dutch court says that even also corporations have a duty of care, and that duty of care to address climate change. And that duty of care is influenced by human rights law and by the Paris Agreement and by science. So they used all these different aspects to interpret the content of the duty of care. And by the end, they found that the company Royal Dutch Shell has a duty of care to reduce its greenhouse gas emissions. The case, the judgment has been appealed, and we'll still have to see how this continues in the Dutch court system. But we see these kinds of cases against corporate actors popping up in many parts of the world, where we previously, as I said, had to focus on state actors. Now, a lot of litigation is being launched against corporate actors. Here's an example from a similar case to the Shell case, but in France against an oil company called Total. There we don't have a judgment yet, but it has the same kind of logic as we've seen in the Shell case. An interesting new development are also cases against pension funds, against sovereign bonds, against banks. These are not necessarily the actors that you would think are the primary culprits of climate damaging behavior. That's something where we think about mining companies, oil companies. But new cases now are targeted against those behind those companies that actually fund them, that give them loans, that give them credits, like pension funds, like bonds, like banks, and by their financial contribution also support the continuous activities of oil extraction and greenhouse gas emissions. And this is what I mean when I go back to what I mentioned in the very beginning, talking about that finance goal under the Paris Agreement, that third one, which talks about making finance flows consistent with low greenhouse gas development. And now suddenly this finance goal plays into these international, in these litigations, where also the corporate world financing and supporting oil companies, for example, are tried to be taken to account. Here is an example of a very recent case against the National Bank in Belgium, which is again similar to what I just said, a bank that does support certain extractive industries, oil and coal and gas exploration. And here a claim was brought against the Belgian National Bank for failing to consider the climate impact of their investment. Okay, so there's this whole focus on corporate actors now, and the question of how can international law be helpful in these contexts, both in terms of regulating, but also in terms of adjudication against corporate actors. In the international field, we have, of course, a whole area of international law, trade and investment law, which for a long time has aimed or had the aim to decrease barriers to international trade and protect investors and enable free flow of goods and services without any trade barriers. But of course, that may come into conflict with regulatory measures to reduce greenhouse gas emissions, to tax products that are imported from other countries. For example, within the European Union, as you may know, there is a big discussion on a carbon border adjustment measure, which is kind of a carbon tax for imports into the European Union, so that these imports from third countries also have to pay a climate cost. There are a number of very interesting legal discussions about how does that relate to the World Trade Organization's covered treaties. Can it, for example, be justified under Article 20 of the General Agreement on Trade and Services? That is a fascinating, still relevant discussion. I wrote my PhD thesis on this for 20 years ago, but it's still a very fascinating and unresolved legal issue. The same under investment protection. As you perhaps know, there are thousands of bilateral investment treaties, some also between states and investors, or between states and states. And their aim is to ensure fair and equitable treatment of investors, but also protect investors' legitimate expectations when they go into a country and invest there. But again, here the problem is, or the challenge is, what is the legitimate space for countries or for states then to adopt strong climate legislation or energy legislation that can sometimes cut against the grain of protection of investors, which are enshrined in these treaties. And here the whole legal discourse, both amongst practitioners, but also amongst scholars, has evolved over the last maybe 5 to 10 years about how international investment treaties, bilateral investment treaties, can be designed, or if they're older, can be interpreted in order to include the objective of climate regulation within their purview. We also see a very difficult situation here where, for example, investments are protected, for example, under the Energy Charter Treaty. And when we have a country that actually wants to pull out of oil or coal, like, for example, the Netherlands or Germany, we have investors, big companies coming in and claiming compensation from those countries for their lost investment in the oil or coal sector, primarily based on the Energy Charter Treaty. There's currently a case ongoing between RWE, which is a German energy provider who had significant investment in the Netherlands, and the Netherlands now are pursuing a withdrawal from fossil fuel industries. And that claim against the Netherlands from RWE is about, I think, 1.5 billion euros or something. And it is going against the climate policy and measures that the government of the Netherlands is adopting. So here is a space again for lawyers to look at this legal setting, questions of how can the Energy Charter Treaty be interpreted, maybe in a dynamic fashion? Can it be amended? What are the processes out there? Which legal arguments pro and again can be found? But it's a very hot topic. It's definitely a current issue of how to balance investment protection and the need for a strong climate regulation. We also see a number of bilateral free trade agreements or bi-regional free trade agreements, which currently are stagnating. The most prominent one, as you perhaps know, is between the European Union and its South American counterpart, Mercosur, where the whole question is how to deal with climate protection and the deforestation, of course, in the Amazon in the context of this treaty, so that the treaty is based on an international legitimate basis in terms of climate protection. I see that I don't have much time left. I just wanted to point this out to you because this is another fascinating area to follow. It's highly political, but it is also legal, very similar. There's an EU-China free trade agreement where it also has a particular provision on how to deal with investment and climate change. And I only put this out here just to bring it to your attention, because there's a whole host of legal issues attached to it. Other areas of law, and I said I can only drop this onto you, is of course international criminal law. And we already heard Professor Asika mentioning it. There's a new initiative for a definition of ecocide as a fifth crime to be recognized by the International Criminal Court. That of course can only happen by an amendment of the Rome Statute, and that will require states to negotiate something like this. But scholars have engaged into the question of how ecocide could, for example, be a means, an international criminal means to address also climate harms. There was a panel of international lawyers who put forward an ecocide definition earlier this year, and I had the privilege of sitting on this panel. And the reactions have been very, very, very interesting ever since. But it is possible to define ecocide so as to capture climate harms as well. But the question is international criminal the right way to address climate change? And I think it is probably not the best and the most direct channel to pursue this, but it is something that will contribute to raising consciousness around criminalization of climate change activities that lead to significant harm, and the role of law. Finally, we don't only have treaty law, of course, and international law. We also have customary law, which are not written down anywhere, but which parties adhere to due to an opinio juris and state practice. And here we have in particular the prohibition of transboundary harm, which is a very fundamental pillar of international environmental law. And the legal question here is, how can this principle be applied? Is it applicable to the context of climate change harms? Is it something that could give states, for example, a basis to claim compensation from each other, for example, small island developing states that are affected by rising sea level rises and so forth? There is currently an initiative to ask the International Court of Justice for an advisory opinion on partly this issue, but partly also on human rights obligations. But my point here is that it's customary law out there, which comes from a different era where climate change wasn't part of the overall discourse, but is now being applied to the current challenge of climate change. The same with the non-refoulement principle to protect people that migrate across international boundaries. We do know that climate change migrants currently have no protection under international refugee law, but behind international refugee law, there is a customary principle of non-refoulement. You cannot send somebody back if that person's life is threatened in the country where he or she came from. And the very interesting legal discussion is, how can this customary law principle maybe be applied to the concept of climate migrants? We have a whole discussion about very general public international law under the UN Charter, especially Chapter 7 and the role of the Security Council in this new setting of climate change, or climate change impact world. And the Security Council just about a month ago had yet another sitting, another meeting, where the linkage between peace and security and climate change was addressed. Nothing concrete has come out of these meetings yet, and the Security Council hasn't taken any particular step, but the discussion is ongoing. And the legal issue is, how can peace and security, or threat to peace and security, be interpreted in a contemporary understanding, moving away from military conflicts to a wider understanding of what other threats are out there to peace and security that equally needs to be addressed, and what is the role of the UN Security Council. I have a feeling I skipped 2 slides. I don't know where they are. There was one slide on the human rights to a clean and healthy environment. I think they fell out of my presentation. I do apologize for that. Of course, you probably know that the UN Human Rights Council just last week adopted a resolution on the recognition of a human right to clean, healthy, and sustainable environment. Now, the resolution itself is not legally binding, but the question is, what are the normative effects of the recognition of the Human Rights Council on this right? How does it relate to climate change? Will it play into domestic or international climate litigation? And if so, how? So there was a slide on that, which I apologize I missed. And the second one was a slide on the I'm sorry, I don't know where it is, on the UNCLOS, on the United Nations Law of the Sea Convention, which of course is a convention adopted in the 80s, which deals with the ocean, protection of ocean, use of ocean for different purposes, but it doesn't deal with climate change. But it does have some provision on protection of the marine environment, including the high seas. And here an interesting legal question or discourse has started on how far this actually requires also states to reduce greenhouse gas emissions on their territories if greenhouse gases and climate change and increased CO2 levels have an impact on the oceans, not just in terms of warming of waters and destroying of ecosystems, but also ocean acidification, which changes the chemical composition of the water and impacts on life in the oceans. But with regard to oceans, again, we have a whole host of fascinating questions. For example, how to protect small island developing states from losing their maritime zones by sea level rise, because then the baseline becomes smaller, and thereby also the exclusive economic zone where they have certain sovereign rights to fishing and use of natural resources becomes smaller. What the United Nations Convention on Law of the Sea doesn't say anything about how to protect their rights, but some small island states have started to what they call freeze their baseline so that they don't become even smaller by rising sea levels, but they protect it at their current location and thereby aim to protect their exclusive economic zones and their maritime rights there. This raises again a whole area of fascinating legal questions, and the same applies to just disappearing islands and what that means for state sovereignty and of course the people who live there. I think I'll stop about here. I see that I've spoken for about an hour, and that should be enough. Just to wrap up, this was the overview that I wanted to give you, just very briefly going into these different areas. Each one of them holds a host of fascinating legal questions, many open questions that don't really have a concrete answer yet, either because we don't have an authoritative judgment internationally, or we don't have a treaty addressing the particular issue of climate change, or because scholarship is just evolving and we just see this area being developing in front of our eyes. But it's definitely a lot of work that needs to be done, and a lot of fascinating topics to discuss in future seminars of the CCL lab of your university. And finally, here is an interesting initiative that I decided to join. Maybe you may want to have a look at it. And it's initiative of lawyers, pledge on climate change. There's a small video behind here. I can't play it right now in Zoom. But I'll send you my presentation. It's just a 3-minute video about how different legal professions, be they academics, professors, law students, researchers, but also judges or practitioners, decision makers, what role they have in addressing climate change, and what is their possibility to contribute with their respective vocation, with their respective legal background in finding a solution to this overall immense challenge and threat that we're all facing. I thank you for your attention. I close here, and I'm looking forward to any questions that there may be.
Professor Voigt. Thank you so much for this insightful and absolutely fascinating presentation on different areas related to climate change. And personally, I have learned a lot, and I'm sure the participants did. Now we can take the questions, and Ece will help us by taking the questions of our audience.
Many thanks again, Professor Voigt. We have received a few questions. I want to direct them just as in the order that is sent to me. First question is coming from Andre Akbar Martin, and if we can let him, he prefers to ask it via microphone.
Maybe we can read the question, I think. Yes.
Hello.
No. Yes, good.
Yes, thank you so much. And I would like to congratulate for the launching of the CCC Lab. I would like to introduce myself. I'm Andre Akbar Martin. I'm a doctorate candidate from the PACE Law School. And I thank you so much for the very fantastic presentation, Professor Voigt. I always enjoy your presentation. And my question is, to what extent actually the climate finance under Paris Agreement could be interlinked with other financing facility provided by other multilateral agreements on environments? For instance, if you're talking about the loss and damage, to what extent actually the climate finance under PA could be interlinked with the financing facility provided by Sendai Network, for instance? Thank you so much for the opportunity, and once again, congratulations for the launching of the lab.
Thank you. Thank you very much. And this is a really interesting and very important question, because it deals with, one thing is to recognize that there are, for example, climate damages and the need to increase ambition, both on mitigation, adaptation. And another question is how much money is actually available, especially for developing countries that need it in light of their capacities. And here there is a mismatch, of course, between what is needed and what is currently on the table, what's being pledged, what's being provided. Now, there are two things here. One thing is that this is going to be a very, very central topic for the meeting in Glasgow. In addition to closing the ambition gap, that there is on unequal footing is increasing the provision of finance to developing countries, and also agreeing on a new global finance goal. As you know, currently, or in Paris, parties agreed on $100 billion annually, but by 2025, there's also the understanding that this goal has to be increased to a new one, that the 100 billion is just a floor for something new, but there is no yet any agreement on how high is going to be this new goal. Is it 150? Is it 200? Is it 700 billion per year? And I think this is very important, and it plays into that discourse on global equity and fairness of what amount of finance will be made available and when. And the second question, what is it being used for? And here, under the climate treaties, in general, the finance goes to mitigation or adaptation activities. It's supposed to be 50-50. It's not entirely 50-50, but there is no yet a direct link for finance for loss and damage. There's the Warsaw International Framework on loss and damage, but it has, if at all, a very weak link to any financial elements. It's more about capacity building of how to address and avoid loss and damage. But linking to the Sendai framework for disaster risk reduction, for example, it's an interesting one. And I think pushing and asking for it would enable maybe some parties developed country to maybe on a bilateral or regional basis to fund certain other frameworks or multilateral agreements outside the Framework Convention that addresses loss and damage in a better way, rather than trying to push it under the Framework Convention on Climate Change. But this is something that still needs resolution, where the discussions are just right now happening, and they will be happening in Glasgow. But as I said, there are two issues: how much money and what is it being used for, and addressing and financing losses and damages is maybe one of the most controversial issues in the climate negotiations, as you perhaps know. And I think that's definitely a space to follow for lawyers.
Thank you, Professor Voigt. Now our second question is coming from Baran Cankaya. I will read the question. It goes as, what kind of obligations could be imposed over companies in order to realize the aim of the agreement?
Well, I mean, companies are, to start with, they're operating usually within or under the jurisdiction of a particular state. They're usually registered somewhere and not just in a mailbox, but there are also many of those, of course. But the companies that actually do have a real negative impact on the climate system through, oil exploration or mining or whatever they do, they are registered somewhere and they're operating somewhere. And here we have host states. We have states that can actually adopt legislation to address these companies where they operate and where they're registered. And that is partly part of the agenda judgment initially that said, Netherlands has to increase its ambition, and that would also require regulating your corporate actors within your company because they are under your jurisdiction. But of course, we have many companies that operate across boundaries under multi nationalities in different countries. And here the new Shell judgment from the Netherlands comes in, which says actually countries, corporations themselves have a duty of care to reduce their greenhouse gas emissions, at least under Dutch law. We're still waiting for the Total case in the Netherlands. But we have OECD guidelines that play in. They're not legally binding. But there is currently an development in this field where, for example, within the European Union, there is a guidance on mandatory due diligence obligations for corporations, and it actually applies to the entire supply chain, where they have obligations in their along their supply chain to respect human rights and certain environmental aspects, and that becomes mandatory, and that could include also greenhouse gas emissions along the supply chain. And once that is established, it may be judicially reviewable and actually something that corporations will have to think about twice. But by the end of the day, it really depends on national lawmakers and how willing they are to put frameworks around corporations.
Thanks again, Professor Voigt. And the third question is coming from Dr. Serkan Köybaşı.
Hello, I'm Serkan Köybaşı from Bahçeşehir University, Istanbul. I congratulate also the launching of the Climate Change and Law Laboratory. And as we say in Turkish, hayırlı olsun. So thank you for the presentation, Professor Voigt. My question is about the legally binding effect of the Paris Agreement, because you stated that the agreement is legally binding for the countries, ratifying countries. But as far as I know, only a couple of countries, ratifying countries, are on the track to comply with the duties and responsibilities under the agreement. But the others, including the developed countries like Norway, Germany, United Kingdom, France, are off track, and they are about to violate the agreement. So what will happen to these countries? Are they facing some sanctions? Because a rule without a sanction is not binding, right? So what kind of binding effect of the agreement that we are talking about here?
Thank you for your question. And that's really the absolutely central one when it comes to the Paris Agreement. And I think it's really good to explore this in detail, maybe together with the audience here. As I mentioned, the Paris Agreement is structured in a way that the legal obligation, the rule in a way, is to put forward what is called an NDC, a nationally determined contribution. So parties have to send in a document, basically, a couple of pages where they state, this is our NDC, this is what we're going to do within the next 5 or 10 years, this is our plan. So the obligation is really only to have that thing and send it to the UN Framework Convention so it can be put out publicly on a registry and everybody can read it. It is not a legal obligation to fulfill what they write in their NDC, to achieve their target. This can be criticized, and it has been criticized. It's a weakness of the Paris Agreement, but it was a necessity in order to get to the agreement. It wasn't possible to also make the content of the NDC legally binding and reviewable through the processes of the Paris Agreement. It's a big, big trade-off, but the alternative would have been no agreement. And you have to ask, what is better for the world, having that Paris Agreement with its, just the way it is phrased and it has its weaknesses, or would it be better to have no agreement at all? And we go back to the so that you can have different opinions on it. But the fact is that whether parties are on track with their NDC is something that cannot be, or is not part of the obligation or rules under the agreement. But from a legal perspective, you can also ask, what role does Article 2 play? What role does it play that you have committed to this overall temperature goal or finance goal? Does it have any legal effect, any legal impact on how you have to decide or define your NDC? But from a very black and white, strict legal obligation, it's really only to have that NDC, send it in, and also report on it. And I have to say that because I was co-chair of the Paris Agreement Compliance Committee, which exactly looks at the questions whether parties are in compliance with their obligations, but these are only the core legal procedural obligations that parties need to comply with. Under domestic law, many parties, as I also said, included their Paris Agreement NDC goals into domestic treaty, climate laws, climate acts. Norway has done that, many other parties. And there it suddenly becomes hard law. So if you have a domestic climate act, like Germany has, and many others, which says, by 2020 or by 2030, by 2050, we are going to achieve X% of emission reductions. And you write this into a domestic law, which is then adopted by your parliament, then it becomes law, but domestically, and can be reviewed by national courts on whether this is being achieved or not. And this is what currently is happening in much of the climate litigation. And we would not have those domestic law without the Paris Agreement, but it's more of an indirect effect of implementation of the agreement.
And now it's Ece Saygılar's turn for a question.
Hello, Professor Voigt. Thank you for the opportunity for the question, and thank you for the presentation. I'm law student. I'm junior law student at KHAS University. I want to ask a follow-up question for the first one. You mentioned about guidance and supervision, supervision about state parties, about emission reduction goals. But we talked about funds too, and I think state parties will be beneficial position by climate financing by agreement. So are there any control mechanisms, superintendents for those funds according to use of those funds?
For the use of those funds, the funds are, they're channeled through different channels. You have the Green Climate Fund, the GCF. There are a lot of bilateral agreements on how to fund certain aspects. And each channel operates according to its own guidance. For example, the Green Climate Fund has its own, big booklet of guidance on how this is supposed to operate, and there's also possibility to review whether that corresponds to the rules of the GCF. For each bilateral regional agreement, on donor agreement, there are terms of reference upon which this is based. For example, I worked for a long time for the Norwegian government on REDD+, that's forest protection in developing countries, where significant payments were made to, for example, Indonesia, Brazil in the earlier days for their reduction of deforestation. But each one of these agreements is based on a very detailed contract or agreement between the respective countries. So you have to look at the whole range of different agreements internationally, bilaterally, and between the respective countries. But under the Paris Agreement, there is no review on how the funds are being used, what they're being used for, but there is control of whether parties actually put forward information on how developed country parties put forward information on how much finance they provided and how much finance they will provide. It's an ex post and ex ante information obligation. And whether they put forward this information or not, that is something that for example, the Paris Agreement Compliance Committee will pick up.
And thanks again, Professor Voigt. And now Mr. Fatih Duran will pose this question.
Hello. I would like to present my thanks to Professor Voigt and KHAS University for this excellent meeting first. According to various research, it is well known today that animal farming contributes to greenhouse gas emissions through several routes. It is a fact that livestock industry has a considerable effect on climate change. So as a vegan and lawyer, I wonder if it could be possible in the near future to take an action in international law, like forcing or at least stimulate states or to forbid or restrict animal consumption and livestock.
That's actually a very interesting question, because when we talk about climate change and that problem, it's actually really, really complicated, because you have different greenhouse gases, under the Framework Convention on Climate Change and Paris Agreement, they're all put in the same basket, and they can be, calculated in terms of their global warming potential. But we're looking at carbon dioxide, we're looking at methane, we're looking at nitrous oxide. But if you look into a particular sector or one particular greenhouse gas like methane, which you seem to indicate, you delve into a whole new area and complexity and specificity of an issue. And here what you're indicating is both related to agricultural policies and practices, but also lifestyle choices and nutritional choices. And here you're crossing into an area where people feel very strongly about what they eat or what they don't eat. But it will be very important to address methane emission from agricultural practices in order to be able to address climate change. And what has happened recently is methane comes from several sources, including cattle stocks and other animal farming, but also it's released by melting permafrost and increases problems there as well. There have been regional initiatives, but also initiatives between some countries, for example, the United States and some other countries, which look at just an agreement on methane, on understanding of how to address methane, just one of the greenhouse gases, and looking at specific measures that can be undertaken to address emissions from methane, because you look at one sector and it might be able to address it. Because if we look at energy, it's primarily CO2, but agriculture, it's CO2 and methane, and it may have to respond to or be responded with a different set of measures than, for example, switching to renewable energy. But it's a very interesting question you raised, because it just points to the complexity of climate change. Like everything we do is somehow has an impact on the climate system, and how we travel, how we eat, where we live, what kind of clothes we wear, and so it's this is perhaps one of the reasons why it takes such a long time and it's so difficult to find an adequate response to climate change. But maybe breaking it down and looking at specific sectors or practices like you indicated may be a helpful way forward.
Thanks, Professor Voigt. Next question is from Zeynep Ertuğral. If she prefers to use her microphone.
Hello. I am a law student at KHAS University. Thank you for your presentation. I want to ask two questions. First one, should our priority be to raise awareness of the students or to increase legal enforcement in order to mitigate the effects of the climate crisis? And does the Paris Agreement have economic benefits for countries? Thank you.
Very good questions, Zeynep. It's really, if I think about the Paris Agreement, although it's an agreement between states and it's international law, but the way it is designed, it is really an agreement to engage stakeholders, because nationally determined contributions are nationally determined, and it means there are national processes where stakeholders hopefully are engaged and should be engaged through hearings. But there's also a whole article, for example, it's Article 12 that deals with capacity building, communication, strategies and so forth, which still needs to be operationalized. There's so many aspects of the agreement which haven't yet really kicked into motion because everybody was thinking of NDCs. But if you go deeper into it, there's much more to it. And I think everybody should be part of the solution, and the agreement actually is an agreement that is kind of mobilizing or aims at mobilizing all of society, including students, including teachers. And I speak a lot about the Paris Agreement. What I find very interesting is that you have schools, you have universities, you have cities, you have kindergartens that say, we are implementing the Paris Agreement. It's like, what? No, we negotiated this between states, but you have kindergarten children who know about the agreement and know what it says and think about what could be done. And so it's like trickling down its message to so many layers of society, and hopefully enables and empowers them to participate in these processes domestically. And if they're not participated, it gives them a legitimate voice to criticize those that make decisions that they're not heard, because this is what the agreement actually requires. Now I have to admit that I forgot your second question. Could you briefly remind me what it was about? Oh, it was finance. I'm sorry. Could parties benefit from the agreement? Sorry. Well, yes. In general, everybody should be able to benefit from it, because as we know, the costs of climate impacts and just think about floods and fires and sea level rise are so much higher than the combined costs to try to address the issue. It is costly, but the costs of not doing are so much higher that it is beneficial to implement the agreement just from the outset. But it is also, of course, meant to be something that helps developing countries to raise their capacity in terms of financial capacity, technological capacity, human capacity, by having a right to finance. Developed countries have an obligation to transfer finance and technology to developing countries. The corresponding right is a little bit difficult because it's not an individual right, it's more of a collective right. But they have channels like the Green Climate Fund, like other multilateral channels to actually access these funds. And it should be, not just financially beneficial, but it should help them to increase their ambition and their climate policies above and beyond of what they could do if they wouldn't have international finance.
Professor Voigt, we're about to exceed our time, but if you let me, we have two last questions. Okay, and then the next question is from Gizem Dursun.
Hello, Professor. Considering the negative conditions in the world today, will the Paris Agreement alone be enough?
Gideon, that's a very good question and a very difficult one to answer. I don't think it will be enough. It's not a silver bullet that has, the answer and the solution to everything, but it is an enabling agreement. It provides a very, very important political consensus and legal consensus that should allow, the world to act on. Whether it will is something that remains to be seen, but we don't have anything else right now that has the same caliber as the Paris Agreement. But it was kind of part of my lecture when I showed those different areas of international law. It is actually what hopefully will be enough, all these different areas working together and from their respective fields, thinking through and addressing climate change and providing the legal solutions. The agreement, the Paris Agreement itself can't be enough. But I think, capturing and galvanizing political willingness and translating this into legal answers, whether through legal changes, amendments, interpretations, applications, adjudication, there's the whole range. That could be, at least on the international level, the toolbox that might be enough, but not the Paris Agreement alone. But it's a very good question that you posed.
Next question is from Nazlı Çiçek Semercioğlu. We can't hear you, right?
Okay, now can you hear me? Okay, great. Thank you very much for your insightful remarks. I'm a PhD candidate at Bocconi University in Italy, and my research covers issues falling within the scope of the rights of nature movement. And in particular, I compared the human rights to water and sanitation with the rights of nature to water. And about the rights of nature, I realized that there are like two different views, and some authors claim that the nature should be granted legal personhood in all jurisdictions, while others assert that this is not necessary in jurisdictions where environmental laws implementation is relatively better, such as the EU. So I was wondering if you could express your views about the role the introduction of rights of nature may play in combating the adverse effects of climate change. Thank you.
Thank you. That's a fascinating question, and I can't really provide an answer other than just guessing, but it is something which I found very interesting to explore, because it's a different approach. You grant legal state personhood to objects of nature like rivers or national parks or mountains, as we see in New Zealand and other places, and they have a right on their own for protection or their ecological function. And the question, how could climate change come in, and would that help to define or decide on a response to climate change? I don't know. I think it might help because you have very vulnerable ecosystems, and these are the first to suffer from the impacts of climate change. And once you have a vulnerable ecosystem, it's gone. That's it. And if you consider this, that maybe that ecosystem, a swamp or whatever it is, has an individual right, you may link back this to higher ambition on climate change. But I haven't seen anything on this yet, at least not in litigation. But it's definitely an interesting approach, and it's slightly linked to the similar discourse under human right to clean and healthy environment. Although here we're back to humans, but it is also extending the scope of rights either to non-humans or the scope of human rights to human issues like the environment, just opens for new discourses which are not entirely explored yet with regard to climate change. But I think it's a very important discourse to be had. And congratulations to your PhD topic. It's really timely, fascinating.
And Professor Voigt, we have one raised hand and one more question. If the account TechnoC9 would like to ask their question or comments. Okay, then Sophia may ask the questions. Okay, I may read the question. How should the EU contribute in the light of climate change law? EU regulations do not only promote climate positive behavior. Agriculture subsides can be problematic, for example, yet the EU influence is quite big in several respects. Would the rights of nature movement add possibilities or more difficulties in your opinion?
Yeah, it kind of links back to the previous question, just in a specific context of EU agricultural policies, which is of course a very important sector in the EU, and maybe the one that still needs a lot of thinking through in the overall package, Fit for 55 and the climate, the new Green Deal. I don't think, and maybe I'm wrong, that in that particular specific policy aspect of the EU rights of nature may be such a game changer. I think this is still an idea which is a little foreign to the EU, and especially at the at the EU level. Maybe some member states may be more inclined to think about it. And I know that in Sweden there's a discourse. I think in Norway it's rather an exotic, or looked upon as an exotic thing to do. But I guess if at the level of the EU member states gains more recognition, it may bubble up to the EU level. But I wouldn't expect this to come from the EU level. But I might be wrong. But that doesn't solve the issue of the agricultural policies. This is another topic which really needs addressing and resolution. And I think there still is a lot of work to do.
Mr. Baranjankaya raised their hand, so.
I've got two questions. First of all, my question is that, what do you think about applying economic sanctions over the state which does not comply with the provisions of the agreement? But this is not a legally binding, this is just an economic sanctions. My first question is. My second question is that, that we are using print monies our money system is depending on printing. And now, what do you think about digitalizing the money? My second question is that.
Yeah, I'm not sure I got the second question entirely, but let me try to answer the first one, and maybe you can then help me understanding the second one. But the first one, economic sanctions for states that do not comply with the Paris Agreement. I think this is a really interesting question. Well, first of all, under the Paris Agreement, there is no possibility for economic sanctions. For example, the Compliance Committee has no possibility for economic sanction. But under international law, you may know that there's the concept of state responsibility. And if you have an internationally wrongful act that is attributable to a state, then one of the consequences could be applying economic sanctions against that state as a countermeasure for its illegal act. And the question is, when would you have an internationally wrongful act under the Paris Agreement, which under the concept of state responsibility could lead to the possibility to apply economic sanctions? And here, of course, breaking the obligations under the Paris Agreement, just not having an NDC or not reporting, not doing anything under the agreement, could amount to an internationally wrongful act. But then you always need to, another country saying, country X is violating its obligation, thereby that's an internationally wrongful act, and now we are entitled to countermeasures, including economic sanctions. You usually don't have that we haven't seen this yet. But we have an example for economic countermeasures, for example, with regard to to Brazil. I mean, what we're currently seeing in terms of trying to negotiate that EU-Mercosur agreement, it doesn't contain economic sanctions, but France, for example, and President Macron of France is very explicit, saying that the current policy in Brazil with Bolsonaro regime not doing anything against deforestation is illegal under international law. President Macron doesn't really substantiate exactly where the illegality lies, but he says it's illegal under international law, and therefore there's a possibility for economic sanctions, which can take several forms. But calling back, for example, your investors, disencouraging them from investing into Brazil and something amounts to a certain economic sanctionable policy. But it is, it's an interesting field where you have economic thinking, but also international relations and international law all mixed up together. And, creating some more clarity on what exactly would enable economic sanctions under the Paris Agreement is a very important question. And I think it's one that hasn't really found any specific answer yet. Yes, the second question, I don't know, it was about the money we're using. I'm sorry, I just really didn't hear exactly what the second question was about.
Mr. Baran, can you maybe repeat your question?
My second question is that eradicating banknotes have any beneficial over the climate change? My second question is that just using digital money.
Yeah, I can only say I don't know. Sorry, I really don't know. I cannot assess all the implications of switching from physical currency to virtual currency. I've heard discussions about it, but it's sort of above and beyond what I currently can understand. So explore it further, but I can't give you any answer. I'm sorry for that.
Yes. I think our questions are finished as of now, and we have come to the end of time allocated to us for this event. I would like to thank everyone in the audience for their insightful questions, and to you, Professor Voigt, for your excellent answers. I hope everyone enjoyed today's lecture. Before we finish, I would like to point out that our CCLLAB is open to everyone, and we will be very happy to have any supports or ideas from you too, and to be in contact with you after the seminar. So if you wish to be informed our future events and to be in contact with us, please send your emails so we can include you in our network. And we wish you stick with us during the next month with our second seminar. And Professor Voigt, before we finish, I would like to hand over you for your closing words.
Thank you so much, Dr. Esiha. I just want to thank you and Ece for inviting me, and the university, the KHAS University for, as I said, for making this happen, for establishing the CCLLAB initiative. I think it's really important. But first and foremost, I would like to thank the audience. It's been terrific. I really enjoyed the questions, and they show so much understanding and interest and curiosity, which is so important in this world, which is, as I said, which is so complex, and where not all questions, if any, or answers are clear cut. So having creative and curious minds that explore different avenues is the most important value that we have really to move our world forward. So I thank you so much for inviting me. I thank the audience for their questions and for their attention, and I wish you best of luck. And I would like to stay in contact and be copied in your activities, because it's really fascinating to follow. Thank you.
We will certainly invite you in our future events, that's for sure. Thank you so much, Professor. Thank you all participants, and we look forward to seeing you in our future events. I wish you good evening.
Thank you. Bye-bye.